Hey everyone, this is Eddie, and I would like to welcome you to this review of question number 2 of the California bar exam that was administered in February of 2017. And for those of you that have not seen this particular question, which means you did not take this exam, I want you to take it and then look at this review. And you will see that timing was definitely, if applied properly, the use of a timing technique was definitely very useful, and also the use of keywords. Okay, so if you're not taking this exam, I want you to look at this 2-hour course here, 22 hours, but it has very powerful strategies. So check it out. I'll leave a link in the description below. So check it out. Now, those of you that did take this exam, I want to wish you all the best, and I sincerely hope that everyone watching this passed. Okay, now let's go on and let's review. So, part 1. So there's going to be part 2 below. Can Betty prevail against Steve in an action for fraud? So I'm going to briefly discuss choice of law information. Okay, sale of real property falls under the common law, and there was a written contract. So discuss that very briefly, and then I'm going to go into the discussion of fraud, because the fraud can be a defense to a contract formation, and I think Betty might want to get out of this contract here. Okay, so Betty is alleging fraud, and what are the elements for fraud? So we have a false representation or an omission of a material representation. So first I want to see if there is a false representation on the part of Steve. Okay, and of course there are other elements here, but we're going to stick to this one for now. So if there is a false representation by Steve, we want to know what it is. So let's go ahead, and I know there was a parking lot issue here, and also there was a murder issue. So let's talk first about the parking lot. And of course we're looking at the false representation, and Steve stated, he said that he was allowed to park in a car in an adjacent lot for $50 a month, and also that he had no reason to believe that Betty would not be able to continue the parking arrangement. So was there a specific statement by Steve? Again, we want to make sure that it was not inferred, because then Betty would have a hard time against Steve if that's the case. But here it seems like it was very specific. Now I want to know if there was inducement and reliance. And here you can make an argument either way. So let's see, this is just examples that I came up with, and again, you can argue otherwise. So did Betty act in reliance? So here I want to discuss that the parking lot situation was discussed during negotiations, and it was located in a congested urban area, and parking was important to Betty. And also Steve knew that this statement was not true, and as we can see later on that the value of the property is actually lowered without the parking lot. So I'm going to argue that inducement and reliance is present. So it could be that based on this that Steve is liable for fraud for that parking lot. Now, I think a lot of people had more questions about the murder, and was that a material omission? And the duty to disclose the murder can arise because it seems like that Steve did know about the murder, because the facts state that immediately before buying the condo that the previous owner had died or had been murdered there. So let's be specific there. So does Steve have a duty to disclose that murder? And a duty to disclose can arise if it's material. So the question is, was the murder disclosure material? So we have 3 scenarios, and 2 of them we'll focus on, and 1 of them is just an example. So let's talk about the common law, because we are under the common law. And I'm going to mention caveat emptor. Remember, I have to pick one. I have to pick whether it was material or it was not. So we have caveat emptor. Let the buyer beware, and the seller that disclaims warranties. And of course, you might have some exceptions like fraud. So does the duty to not disclose the murder fall under fraud? And that's not always the case under the common law, and of course it's a gray area. So you can say there is no duty to disclose the murder. Some of you said that, and that's fine. Remember that for a question like this, the bar graders want to know your analysis more than your conclusion. And others said that, hey, there was a duty to disclose. And some reasons for that is because it might have a negative impact on the property value. And a murder taking place may fall under marginalized real property, so you have to disclose that. And also land defects that only the seller knows can trigger a duty to disclose, and a murder can't fall under that category. So based on that, the seller does have a duty to disclose. That's common law. And just a way of setting the example here, setting an example of statutory law. California does have a 3-year limit, so if a murder took place within 3 years, then the seller must disclose. But again, we're under the common law, and as you can see, it's a gray area. Make your argument. And I have to pick something. Okay, I have to pick a choice. I'm going to say that the duty to disclose the murder did not arise. There was no duty to disclose. Okay, that's what I'm going to say. And also other analysis that I can use is this: the buyer never asked, and the reason for the lower evaluation of the home is partly due to the disclosure of the murder, and also the lack of parking space. But notice that word, partly due. And I think you could have used that word. So that's one of those key words that you definitely want to make a lot of use of. So this shows that it was not a material representation. And of course, the words partly due are subject to speculation. And again, the facts don't state that a duty to disclose the murder did arise. So the conclusion to this is that no material omission is present. No duty to disclose on the fraud. But I want to say this, of course, I just want to remind you that fraud was met under the parking lot situation. So the conclusion that fraud is met and subject to defenses. Seller's defenses to fraud. I want to mention this very briefly. Pro evidence. Steve will probably say that, hey, we have a pro evidence rule here. You can't bring up a statement. And there's probably a deed here, because it says that there was no deeded parking. And of course, the way you convey real property is through a deed. And we do not know if there was an integration clause, and that is questionable. It's not a very strong argument for the seller. So I'm just going to briefly address it. If the pro evidence rule was applicable, and then I'm going to say that, well, I'm going to mention the exceptions on the oral condition. Do we have a condition or a promise here? Was there conditional language? Doesn't seem like it. I conditioned that, and it's probably not on the deed. Okay, and of course, it's not his parking. It was adjacent. So I don't think it was a condition. That's what I'm trying to get at. But can there be a condition, an exception on the fraud, an exception to the pro evidence rule? As we said earlier, there can be fraud based on that parking space. So if there is if Steve does have a defense in the pro evidence rule, then he can come in and say, hey, there was fraud. So let that statement in. So conclusion, there is fraud based on that parking space representation. So now I'm going to go to part 2, and I'm going to look at damages. Compensatory damages, again, this one area does have its own elements, but you can also include other areas here like consequential damages, expectation, incidental, reliance, and we'll talk more about this. And the purpose of this is to make the plaintiff whole and to put them in the position they would have been had the contract been properly performed. So I want to discuss the cost, the certainty, foreseeability, and avoidability. And I want to keep the duty to mitigate. I want to keep that in mind as well, certainty. So let's talk about that, because there seems to be something about a bathtub. And well, let's just go into it. So Betty paid $200,000, and the market value seems to be at $160. And so there's a difference there of $40,000 due to the disclosure and the murder, and partly due to the parking situation. So get that, okay? I know that was one of those key words, partly due. So the amount of the parking spaces that Steve is liable for is subject to speculation, because a home without a parking spot could cost 99% of the devaluation, or it could account for 1%. We don't know. It just says that it's partly due. And again, I want to say this, that the question asks what remedies are reasonably available, not the amount specific amount or what remedies the party should elect. So I'm just focused on the reasonable damages that are reasonably available. Okay. So let's go ahead and go into unavoidability, foreseeability, and certainty, and let's include that discussion of that bathtub. So we knew that Betty made improvements that cost $20,000, and she also made some renovations involving a bathtub that amounted to $2,000. So it's unclear if that whole bathtub renovation was an improvement. It does have 2 showers. It can be argued that 1 bathtub and 1 shower can increase the value of the property, whereas 2 showers can lower the value. So the impact is unclear. But it does seem that Betty could have avoided the whole bathtub modification. So you just want to keep that in mind. Expectation, damages, difference between the contract price and the market price. And there we run into uncertainty and exact monetary figures. Because like in my situation, I said, hey, okay, Steve is liable for the parking, for the liability there for the parking lot situation, but not for the murder. So I gotta keep that in mind. Consequential damages, what damages are foreseeable, and may touch on what was contemplated. So for the damages for the parking, of course I said yes. For the murder, I'm also going to discuss that, but I'm going to arrive to the conclusion that it's only due in part. It's only part of the devaluation. And remember, I'm gonna just do this very briefly because I know that I'm running out of time here. All right, Reliance. I think Reliance was big in this case. And this is when you want to place the plaintiff in the position he would have been had the contract itself not have been entered into. So we are looking for out-of-pocket expenses. And the facts do tell us that there were some improvements made on the part of Betty, and they amounted to $20,000. And also duty to mitigate there, she removed the bathtub, so that could lower the price. So that might come into play there for Reliance. Duty to mitigate. Incidental, for this you may have to make up some associated cost, and there was a parking space there that was contemplated, but then they said, hey, you can't have it, so now Betty has to pay $100 and walk an extra block. Okay, so the cost for that, cost to search for that parking space. Now I'm gonna just mention this very briefly. Okay, not heavy on the facts there. Restitution, I definitely want to mention that it was there unjust enrichment. So it seems as if Steve was unjustly enriched by about $40,000. Again, it's not certain. Rescission, there's fraud, yes. Punitive damages. So for that, they're not available for a breach of contract, but they are available under fraud. So I think Betty here can be awarded punitive damages, and that's how I would answer that. So hope this helped. Until soon.